Okay, so one of the first things to make sure that you get right in employment relationships is the starting point. So I'm just going to talk a little bit about how employment relationships begin and what some of the laws are around that. So, how does it begin? Well, an employment relationship begins at the point where an employee has accepted a letter, or not necessarily a letter, but an offer of employment from an employer. And once that offer has been accepted, then that relationship continues until one or both parties terminate the relationship in a lawful manner. And that's the life cycle of a normal, harmonious, unproblematic employment relationship. An employer employs an employee. The employment relationship proceeds until it's terminated in accordance with the law. So the presumption is that when somebody is employed, they're a permanent, ongoing, continuing employee. But there are two main ways in which parties can enter into an employment relationship other than a permanent one. And I just want to discuss these in this video. So the first one is a fixed term employment. So employers are permitted by law to employ people on fixed term agreements. However, there are quite strict laws about how fixed term employment agreements can be entered into, what needs to be done, what needs to not be done. These are set out in section 66 of the Employment Relations Act, which we'll have a look at in a minute. And the important thing about this provision of the Employment Relations Act is that if this section is not complied with, the onus really is on the employer to make sure that this section is complied with. Because if it's not complied with, an employer may find himself or herself in the situation of having an ongoing obligation of employment for somebody whom they had no intention of taking on permanently. So it's really important that fixed term employment is organised properly. The other possibility is that at the end of what an employer might have thought was a fixed term employment, they discover they haven't been compliant and they find that the person whose employment they've terminated takes a personal grievance against them for unjustified dismissal. So it's important that that this process is got right. Let me just go through section 66 of the Employment Relations Act now to point out what these elements of the legislation say. So an employee and employer may agree that the employment of an employee will end. This is specifying an end, circumstances of ending, at the close of a specified date or period, so that's at a time, on the occurrence of a specified event, or at the conclusion of a specified project. So they're the circumstances where employment can be deemed to be carry on up until that point. However, before such an agreement can be entered into, the employer must satisfy these two criteria. It must have genuine reasons based on reasonable grounds for specifying that the employment of the employee is to end in that way, and has to advise the employee of when or how his or her employment will end and the reasons for his or her employment ending in that way. So there need to be proper reasons for the employment being other than permanent for a fixed term of employment, and that needs to be spelled out, both the reasons for it and the circumstances for the the circumstances at which the employment will end. The Act then goes on to say that the following reasons are not genuine reasons for the purposes of the section to exclude or limit the rights of the employee under this Act. So you can't engage in fixed-term employment relationship as a way of circumventing other obligations under the Act. B, to establish suitability of the employee for permanent employment. We'll talk about that in a moment, but you cannot use fixed-term employment as a we'll see how they go. And I know that sometimes this does actually happen with starting off with new inexperienced teachers at school. But it is a breach of the rules to employ people on fixed-term employment if that's the purpose of what you're trying to do, to check out whether they would be suitable for ongoing employment. And also you can't do it to try and get around the rights of the employee under the Holidays Act as well. So you can't use it to get around the law, and you can't use it to as a sort of a trial period. If an employer and employer agree that the employment of the employee will end in a way specified in subsection 1, the employee's agreement must state in writing. So in the employment agreement, it must be written down. I mean, that some people are employed without employment agreements, but if you want to claim that this was a fixed-term employment, it absolutely has to be in writing. Must state in writing the way in which the employment will end and the reasons for ending the employment in that way. So they are the provisions in subsection 1, and they need to be spelled out in the employment agreement with the employee. Failure to do this, failure to comply with section 4, including failure to comply because the reasons for ending the employment are not genuine reasons based on reasonable grounds, does not affect the validity of the employment agreement between the employer and the employer. What that means is that you can't say, we didn't comply with subsection 4, so therefore it isn't a genuine employment agreement because it isn't compliant on those grounds. It is a genuine employment agreement. It definitely is. So you can't use that as a way of getting out of it. However, in number 6 here, if the employer does not comply with subsection 4, the employer may not rely on any term agreed under subsection 1 to end the employee's employment if the employee elects at a time to treat that term as ineffective, or as having been effective to end the employee's employment if the former employee treats that term as ineffective. So effectively what it's saying is if you do not comply with subsection 4, that is, you don't specify the way the employment will end and the reasons for it ending, then you cannot rely on subsection 1 to end the employee's employment. So you're stuck with the person effectively because you can't end it on the basis of this being a fixed term agreement because you haven't satisfied the requirements of the fixed term employment agreement. So it's quite brief, it's quite clear. The things that need to be done to establish if an employment agreement is a fixed term employment agreement, and as I said, if it's not, if it is, it has to comply with these, and if it doesn't comply with these, then it is a permanent ongoing employment relationship that you have got yourself into with this person, whether that was what you intended to do or not. Okay, so the second issue here is probationary periods. New Zealand employment law now has provision for engaging people as employees for probationary periods to see how they work out. That's why part of the reason why you're not allowed to use fixed term agreements because it's in here, although you couldn't before this and this came in afterwards. But anyway, you can use probationary periods of employment. And the purpose of this is to allow employers to assess the suitability of an employee prior to making a permanent commitment to employing them. However, these probationary periods are actually quite tightly regulated. The rules around them are quite tight, and employers cannot treat them as a get out of jail free card. And I know it was a fair bit of controversy about whether this should even be in the law, and in the election people were saying that it would be removed. And one of the things about it is that often bad employers try to make use of these probationary periods, but they do it in very ham-fisted ways that actually get them into more trouble than if they'd tried it in the first place, because there are still quite strict rules about when probationary periods apply and so on. And these are set out in section 67 of the Employment Relations Act. So let's just hop over to section 67. So section 67 of the Act states at the beginning here, where parties to an employment agreement agree as part of the agreement that an employee will serve a period of probation after the commencement of the employment, the fact of the probation period must be specified in writing in the employment agreement. So it has to be in writing. No verbal agreements. It has to be signed by both parties, that both the employer and the employee agree to this trial period. We'll just skip over B there. It's a little complicated and not quite so important. Failure to comply with subsection 1A up here does not affect the validity of the employment agreement between the parties. So same as with the fixed term thing, you can't say that because there was supposed to be a probationary period, but it wasn't specified, therefore the employment agreement is invalid. That doesn't stand. It is still valid. However, if the employer does not comply with subsection 1A, the employer may not rely on any term agreed under subsection 1 that the employee serve a period of probation if the employer elects at any time to treat that term as ineffective. So it's a bit of a mouthful. Basically, it says that if the employer does not comply with that is putting all this in writing, then they can't rely on the provisions of the probationary arrangements to let somebody go if the employee says, I don't want to go. So if you want to rely on the 90-day probationary period, or up to 90-day probationary period, it has to be in writing or the employee can go, I don't recognise this. 67A says that provision can be for a period of up to 90 days, so 90 days or less. An employment agreement containing a trial provision as defined in subsection 2 may be entered into by an employee as defined in subsection 3 and an employer as defined in subsection 4. So further down we'll see exactly what they mean. So the trial provision is defined in number 2 below. An employee is defined in number 3 below, and an employer is defined in number 4 below. So number 2 below, a trial provision. So this means a written provision in an employment agreement that states or is to the effect that for a specified period, up to 90 days, not exceeding that, starting at the beginning of the employee's employment, the employee is to serve a trial period. And that has to be right at the beginning of the employee's employment, not part way through it, not an hour into it. Really needs to be part of the agreement prior to, at the point where the employment relationship has begun. During that period, the employer may dismiss the employee, and if the employer does so, the employee is not entitled to bring a personal grievance or other legal proceedings in respect of the dismissal. So basically it means that if this is all agreed to by the parties in writing, then the employee's employment can be terminated without any explanation and without that employee having any recourse to legal action in the form of a personal grievance against the employer. So the second thing, the second part of these definitions is number 3, the employee. So the employee means an employee who's not previously been employed by the employer, and that's an important provision. It's supposed to be for a trial period, and so it has to be for a new person who has not previously been employed. It can't be added on later or anything like that. An employer is restricted to a small employer. Somebody who employs fewer than 20 employees are the only ones at the moment who can take advantage of these provisions. Section 5, to avoid doubt, a trial provision may be included in an employment agreement under, and this sections 61 and 63 are related to collective agreements. So it basically means that even if you're employing somebody under a collective agreement, whether they're in a union or whether they're a non-union member, and they start with the provisions of the collective agreement applying, you can still tack on to that collective agreement a 90-day trial period. Section 67B, effects of the trial period. So what does this actually mean? This section applies if an employer terminates an employment agreement containing a trial provision by giving the employee notice of the termination before the end of the trial period, whether that termination takes place before, at, or at the end of the trial period. So prior to the trial period running out, the employer can give the employee notice that their employment will be terminated. And if they do that, the employee in subsection 2 here is unable to bring a personal grievance or any legal proceedings in respect of that dismissal. However, in subsection 3, this does not prevent the employee from bringing personal grievances on other grounds. So the employee's rights as an employee and the recourse they have if those rights are transgressed for harassment, for racial prejudice, for all these grounds that are set out in 1031B to G, the employer is still obliged to respect all of those rights, and there can be personal grievances on those grounds, just not on the grounds of terminating the employment. An employee whose employment agreement contains a trial provision is in all other respects to be treated no differently from an employee whose employment agreement contains no trial provision. So that just sort of states that more explicitly, that the only thing that this probationary period allows you to encroach on by way of employee rights is that permanence of employment. So you can terminate it, but you can't discriminate against them or encroach on their rights in any other ways. And finally, number 5, referring to that subsection 4 applies subject to the following provisions: that in observing the obligation in section 4 of dealing in good faith, the employer is not required to comply with section 4.1a in making decision whether to terminate an employment agreement under the section. So this just reinforces the fact that they are able to terminate it, and that section 120, which is referred to in that last little subsection, doesn't have to be complied with either, and that's the provision that says that employees, if their employment is terminated, can require an employer to explain why their employment is being terminated. So you can't do that under these provisions either. So quite strict provisions that essentially enable an employer to take somebody on under these conditions on a short-term trial period and then let them go if they want, but they are obliged to treat them fairly during the course of that trial period. So these are essentially the two main ways where an employer can commence an employment relationship with somebody that has a finite end to it, or potentially finite end to it. And if these circumstances don't exist, then employers have ongoing responsibilities to their employees, ongoing responsibilities as an employer.